think, Advocate Snellenberg, I think what I would be interested to know is your client has been involved in what the executive has been doing regarding this pandemic, as appears from the affidavit of the minister.
Yes.
All I want to know is, on what basis did the matter become urgent? Was it when your client decided, taking account of what's been happening since March till your client decided to issue its application? Just
Yes.
tell us that, because the fact that you're challenging the constitutionality of legislation doesn't mean that you can come at any time of your choosing and simply allege urgency for the court to entertain you.
That's fair, Judge.
Constitutionalism or points of constitutionality do not suspend the normal operation of court rules. So that's what I want to know. What makes it urgent now when your client has been aware and been participating?
Judge, I'm obviously bound to the allegations, the evidence in the papers, and what the applicant explains is that since the declaration of a state of emergency, and more specifically on the 13th of May, they became alarmed by the fact that the lockdown, which had served its purpose, was simply extended. And in terms of the provisions of the Act, the decision to extend resorts in the exclusive domain of the minister, which actually affects the founding values of our country, in as far as there must be a multi-party democratic government where the people rule. So they explained that on 13 May, they became worried about the manner in which the Disaster Management Act was being used, and the lockdown continued.
Right, continue, Advocate Snellenberg.
My Lord, the nub of the matter is the following.
Sorry, JP. I just had a question for clarity there from Mr. Snellenberg.
Yes.
Could I just ask in understanding urgency, Mr. Snellenberg, is it the manner in which the Act was applied, including its extension, as you say, which takes place without parliamentary oversight,
Yes.
that is really at the heart of your client's discontent?
Yes.
So it's not the existence of the Act in itself, nor the initial declaration of disaster that your client really has issue with.
The applicant also explains, my Lord, that initially they submitted to the...
I know that, but I'm asking as a matter of law, and because I need to understand what are the legal issues that we need to deal with. As a matter of law, they don't take issue with the enactment of the Act and the original declaration of disaster, do they?
My Lord, in retrospect, they do take issue with the declaration, but with Section 23.8 and 26.2, which does not, but does not make such a declaration of a national state of disaster subject to parliamentary oversight. In that context,
doesn't that rather remove your case for urgency from the 13th of May, insofar as that attack is concerned?
My Lord, my Lady, with respect, the applicant also...
I understand the two go together, but your client didn't initially have a problem with the Act or with its use. It was only really when the extension came about that suddenly it became concerned, and then rushed off to court on quite short time frames.
They did, my Lady, and the facts are that they alleged in the papers that the next extension was imminent, and it indeed happened after the application was served. The next extension was indeed granted, and obviously the threat lingers that if it be decided by the designated minister that matters are such that then the country can, or any part of it, may be reverted to either level 4, level 5. And therein lies the urgency for the applicant.
Okay, thanks, Advocate Snedenburg. You may proceed.
I will step off this point because the issues raised by the court really the crux of the matter. We have referred the court to the Ramakatsa-Magashule decision of the Constitutional Court, where we respectfully submit it was established that the nature of the rights do play a role with regards to urgency, and in this matter, obviously the people are supposed to govern the country, and we respectfully submit that at this stage the government for a large part is governed in terms of a DMA, and has been since the declaration, and therefore public interest and the nature of the rights at play, we respectfully submit should be a material consideration, as well as the legal principles applicable to delay. If the courts would find that there's a delay, the question remains whether the applicant will be able to obtain substantial redress if the normal course of proceedings is followed with regards to this application. So we respectfully pray that the court will enroll this matter for hearing as an urgent application.
Right.
The second issue is a separation of issues. Now, this maybe ties in to an extent to the urgency issue. The court will remember that, or be reminded that the first and second respondents addressed correspondence wherein they explained that it will take them weeks to collate the record of decisions that they are called upon to produce. They did not give an estimate of how long that would take. The applicant was prepared to extend the DAs with regards to the review. A dispute came into existence with regards to whether Prayer 4 forms part of a review or is in essence a review. The first and second respondents did not revert after being requested to just supply the legal basis for the contention. They simply filed the answering affidavit in terms of the extended period, wherein they hold the same view that they presently do, namely that the courts should now, because the applicant enrolled this matter on an urgent basis, dispose of Prayer 4 and 5. Prayer 5 obviously relating to reviews without the record. My lords and my lady would have noted that we have filed supplementary heads, short supplementary heads, where we just drew attention to the pertinent judgments by the Constitutional Court and the Supreme Court of Appeal, and basically stating that the court cannot finalize a review or review action, any action for that matter that is reviewable, but more specifically and pertinently where there are constitutional issues at stake without the record. And the state has an obligation in that sense, also sourced from the Constitution, to assist the court and to make available the necessary documents. Now, the applicant understands if the respondents say that they have, it's a challenge for them to produce the record because of the fact that it compiles or comprises of so many pages. Obviously, the applicant is not privy to the amount of documents that will be relevant or pertinent to the review. That is something that the first, second respondents will know. But we respectfully submit without saying to the applicant, well, we'll be able to do it in this amount of time. It's virtually impossible for the applicant to make a value judgment with regards to that matter. And in that essence, to be able to amend VDAs, to simply demand that the applicant abandons VDAs that were set, and to state that it will take weeks takes one past the provisions of Rule 53. So that left the applicant in a bit of a hotspot, and its approach, in light of the issues that it deems very important and in public interest, was that there can be a separation of issues. Now, if Prayer 4, as the respondents' content, involves a review that needs a record, then the court will obviously not review such conduct without a record. Point Prayer 2, however, concerns the constitutionality of the sections of the Act that the applicant asks the court to consider, and or the conduct pursuant thereto, and that can be disposed of without any inconvenience.
I think, Advocate Snellenberg, I think just clarify for us on which basis you or your client wants this matter to proceed. We've seen all what you're telling us now. It's in the papers. But your client seeks declaratory relief as well as review relief. You've just talked to us about the intricacies of the sparring between the parties as far as the presence or not of a record. That affects the review part of the relief. But can you clarify for us on what basis your client wants this matter to proceed? It's your client that came here on an urgent basis.
Yes.
Yes.
Well, the matter can proceed, definitely. Prayer 2 and 3, obviously, which is an evaluation by the court.
Yes.
Of the constitutionality of the provisions that the applicant has raised. There's no suggestion that amounts to a review proper, and it is a matter of law.
Right.
I'm constrained in terms of the constitutional court rulings to concede that if any relief relates to a review, that this court must be comprised of the record and the reasons for the decision. And that is in the interest of justice. But we respectfully submit Prayer 2 and 3 can conveniently be heard and adjudicated at this stage. It is not necessary for a record. It is a matter of interpretation, and obviously the evidence has been placed before the court pertinent thereto.
Okay, so as far as the review proper relief is concerned, we should stay clear of that.
I think that the legal principles are quite clear
Yes.
With regards to that, and it's in the interest, obviously, of both the public but also the executive,
Yes.
because the court will ultimately make pronouncements with regards to the conduct.
Okay.
Mr. Snellenberg, may I ask, and I understand conceptually the difference in the nature of the relief that is being sought. But when the applicant launched, but even though there are differences, the nature in which this application has been launched suggests that indeed the factual material upon which the relief is advanced underpins the entire application. That being said, when the application was launched on the 25th of May, you gave the respondents until the 1st of June to provide a record, and a substantial one at that. You did just not want the list of all decisions, but also the scientific and all other data that underpin those decisions. Whether that was reasonable or not, we'll hear. But under those circumstances, the unreadiness of the matter to be dealt with in respect of the review relief is in part to what may be regarded as unreasonable time frame. So why should then the court have to deal with this matter on a piecemeal basis? Surely the court, having regard to the interest of justice, must also be able to determine its own processes, and that might not be a satisfactory state of affairs.
My Lord, obviously, what my Lord says is correct, and ultimately the court must make that decision, that value judgment. The applicant sought to in a pragmatic manner approach the matter, and if the court is of the opinion that in this matter a piecemeal approach is not ideal or not in the interest of justice, then that is the court's prerogative, obviously, to do. The applicant has stated why it's important for it to approach the court on an urgent basis, and it relates basically to what I've said under the head of urgency with regards to the manner in which the country is at this stage governed and the extensions are done. That being said, obviously we at the end of the day, the applicant is in the court's hands with regards to whether it is, if it at all, willing to adjudicate the matter in a peaceful piecemeal fashion, meaning that certain prayers be separated from others. That is, at the end of the day, the court's decision to make. And we must obviously prescribe. May I just maybe conclude my answer with regards to that aspect, to say that we still don't have an idea, notwithstanding the filing of affidavits, of what exactly the extent of the time frame is that the respondents claim they need to compile the record. Whilst we must obviously, and as I said, the applicant's not privy to all the documents. So whilst that is an issue and there's no evidence to refute that it will take a time to compile that, and logic probably dictates that, it can also never be a situation where there's an open-ended a request for an open-ended time period within which to do it. Whilst there are very important rights at stake which are affected by the state of affairs. Rightly or wrongly, so the court will at the end of the day will determine that. Yeah. So that is the conundrum that the applicant finds itself in at the end of the day.
Yeah, look, we understand that, Advocate Snellenberg. Yes. This is an important matter. Yes. That deals with an important issue of yes. constitutionality of legislation, and that applies to what's currently happening in this country. It is it doesn't sit well with us to have to deal with a matter that deals with such an important issue on a half-hearted basis, if I may use that language, because we need to have all the facts before us to deal with everything. I'm not deciding the matter. I'm just saying, just explaining the question that Judge Kolapen asked you. You know, there may be room for the attorneys to can still talk and get an understanding as to what are the time periods that are at stake here that could influence your hand or Advocate Trengo's hand as to whether we can proceed today or we can proceed on another day, should the timelines not be unreasonably long. You know, I don't know what the attitude is of my two colleagues on the bench here.
JP, in principle, I don't have a problem with them talking about that, but immediately what will emerge is that I think the record is likely to be a substantial one. There will then, in response to that, be probably a substantial supplementary founding affidavit, and so we have a whole series of papers which could take a while just to get the paperwork sorted out. So I think, subject to what you and my sister says, let's hear the other submissions and make a determination as to whether we hear the application, consider the separation issue, hear the application, consider all the issues, and deal with them appropriately in terms of the powers we have. But we can explore that option, but I suspect it's going to run into quite considerable time frame.
Yeah, I'm not closing that door to the applicants. I'm just mentioning it that it doesn't sit well with us to approach a matter of this importance and magnitude on a piecemeal basis. But Judge Kittley, you wanted to say something?
This really is, it's an exercise of executive power. It's not an administrative Padgett type review where the record tells you what tender, how a tender was granted and why to one party and another. The issues that the applicants raise are quite broad, wide-ranging. And I would imagine, well, I can see from the papers, it seems that the furthest they can go is, a rationality review. And in that regard, I think that to put the whole thing off so that we can get a record of thousands and thousands of pages, I'm not sure how necessarily will assist a rationality review. And I'm not prejudging that issue either. But I really think we should hear the matter and consider holistically at the end of it whether we grant any relief or not, and which relief we grant or not. Could I just ask Mr. Snellenberg? Mr. Snellenberg, I understood, and it's just a question of clarity, and I might well be wrong. I understood that it was paragraph 5 of the relief, that prayer 5 that was in issue rather than 4. Have I got that wrong?
The correspondence, my lady, would have noted the first and second respondents addressed by inclined that paragraph prayer 4 of the notice of motion also constituted a review. I
thought that was prayer 5. I thought the difference was between the declaration and then the reviewing and setting aside, but I might have misunderstood.
By that raise the issue that in prayer 4 amounts to, or at least one of the sub prayers amounts to a review, and that prayer 4 should properly be determined with the review relief. And when the applicant did not immediately respond in the affirmative, they then approached the matter as if and requested this court to then resolve or to finalize the matter, also then prayer 5, which are the reviews. And as they say, on the basis that the applicant has elected to proceed without a record.
I understand. Just what is your position? Has your position always been that paragraph 4 goes with the review or not? That's what I'm trying to establish.
The applicant initially joined issue with that suggestion and asked the respondents to advise as to their attitude, but there was unfortunately then no further communication with regards to that.
Okay.
That means
Thank
your
you.
position, from what you say, is that prayer 4 can also be dealt with.
Yes,
No.
We'll just bear with me for a moment. I just want to get it quickly. It's at 077A.
Yes.
Sorry, what page was that, Mr. Snellenberg?
077, capital A, page 5.
No, we need a case lines reference, please.
That is the case lines reference. It's
077?
capital A.
Raylene, you'll also find it on 006-5. Yeah.
Thank you.
Okay, Advocate Snellenberg, please continue. I think my colleagues are correct, but I wasn't shutting the door. I just want to be understood. I was just pointing out that
Yes.
we could be disabled from handing down a fully transversing judgments that deal with all the issues, but please continue.
Thank you. Judge, we understand that, and obviously, as I indicated, we understand also that it's the court's prerogative to hear a matter on a separated issue or not. We are fully aware of it. Also, that in applications, it's obviously the exception to a rule to separate issues. I will move on to the gist of the matter, and my lords and my lady, I do so with the understanding that our heads of argument and so forth have been filed, and we would like to just address you on those issues. My lord, if we look at chapter 1 of our constitution, we find our founding values. I'm not going to repeat them all, but we have human dignity and the achievement of equality, and the advancements of human rights and freedoms. And then, very important, we have the supremacy of a constitutional rule of law and a multi-party system of democratic government to ensure accountability, responsiveness, and openness. We need not dwell on the Bill of Rights. It's enshrined to give effect to the human rights. Now, the National Assembly and the role it plays, it is elected, my lords and my lady, to represent the people, and what it amounts to and what it ensures is actually that we have government by the people. Now, pre-COVID-19 state of disaster, it was business as usual, and the founding values of our constitution was well, and the people were governing the country. If we may, for a moment, skip the state of disaster and go to what the respondents term is the remedy for the most dire of circumstances. That would be a state of emergency. What the drafters of the Constitution did, and one must accept, very alive to the history in our country of not having the people govern the country. They said that if the most dire of circumstances should occur in our country, we must make sure that the people still govern. And that is what Section 37 does, as well as the State of Emergency Act. The court would note upon perusal of those items, for example, that the state of emergency declaration will be subject thereafter the extensions to the National Assembly, approving it progressively as this state is extended. Section 3.1 of the Act, the State of Emergency Act, provides that the proclamation of a state of emergency should be tabled in Parliament. And Section 3.2a of the same Act confers powers on the National Assembly to disapprove any regulation, order, rule, or bylaw, or provisions of that state of emergency. So we have business as normal or as usual, government by the people. We've got the most dire circumstances, still government by the people. But enter the DMA. The DMA is the elected vehicle for management of the state of disaster. And in terms of a DMA, and this can't be a contentious issue, the executive, being the president and the ministers appointed by him, are primarily responsible for the management of the state of disaster. The minister designated in terms of the DMA for this national state of disaster has wide-reaching powers. For example, we know that the minister herself issued all the either delegations to other cabinet members to issue directions pursuant to her directions, but you also have a power solely in terms of the Act to terminate the lockdown prior to the expiry thereof, automatically after 3 months, or to extend it, which we know has occurred. Now, it's very important, and the applicant has tried to convey this in no uncertain terms. That something had to be done is not the issue. That South Africa faced and faces a dire situation with this disease, a world pandemic, that is not the issue. The issue is whether what scrutiny. And we respectfully submit it doesn't, because what essentially happens in terms of the DMA is that the people do not govern. The people had no say with regards to the declaration or thereafter with regards to the regulations that were issued. If we can move forward to the third and fourth respondents' explanatory affidavit, and they tie in with the first and second respondents, who say, but wait a minute, there has been oversight, parliamentary oversight. Must not forget, applicant, there has been parliamentary oversight. We respectfully say that let's go and look at the facts of the matter. Firstly, we can get guidance from our national addresses that we had since the start of this state of disaster by our Honourable President. And what the President explained to us in that first address of his is that in order to coordinate the entire management, all the actions that would be taken in terms of a state of disaster which is managed by the DMA, a national command council, coronavirus command council, was established for purposes of coordinating the response. That command council, in terms of his second public address, in no uncertain terms, took the decision for the nationwide lockdown. The nationwide lockdown, we don't need to spend a lot of time on the effect thereof. Our country was closed down internationally and locally. It might be that if the people had a say, that the national lockdown could have lasted longer. It might be that they might have had different ideas. The whole idea of National Assembly, obviously, is public debate where the different parties can hear what the other representatives say. They can apply their minds and they can then make a decision. And obviously, this is a democracy. So the majority decision on any issue carries the day. It might be more onerous than what we've had thus far, or it might not. But the fact of the matter is, when the people have a say, and when we are complying with our foundations, our foundational values.
Mr. Snellenberg, can I ask a question of clarity from a point of departure? And that is, do you accept that there's a distinction between a state of emergency and a state of disaster?
Yes.
And then the second part of that is, are you suggesting that whenever there is even a state of disaster, for example, let's say there was a national drought, not just a provincial drought or local drought, a national drought, is your argument that Parliament needs to oversee whatever disaster measures are put in place as regards the declaration of a national disaster in that context? I'm just trying to see where your conceptual springboard is.
Yes. My lady, the difficulty with the DMA as presently enacted is the example my lady mentions of the national drought might not necessitate Parliament's attention. But if there's an earthquake that runs from Cape Town to Limpopo and divides the country in two, that will be a similar national disaster than we have at this stage with COVID-19. And the conduct, and that's what we try to convey, the manner in which the DMA is utilized to deal with this matter raises this constitutional issue.
But then, Mr. Snow,
the state of, so are you saying that peace and order is threatened by COVID-19?
My lady, we're not arguing that this is a state of emergency that we are in. What we are saying is that we know that this isn't just a state of disaster. This is COVID-19 state of disaster, specifically fact-bound. Our country has been locked down, and it's been run not through the multi-party democratic government. It's been run in terms of the provisions of a DMA. And in that sense, taking into consideration the far-reaching effects of what has been deemed to be necessary to combat COVID-19, if I may use that words, has far-reaching implications, and this is not contentious, with regards to human rights, with regards to every aspect of every citizen's right, daily life, the right to survive, the right to live, the right to have trade. And that is not done in terms of a DMA. The DMA doesn't cater for any parliamentary oversight in such a situation. And those are the facts. That is the current state of disaster that we are dealing with.
Mr. Snellenberg, therein lies my difficulty, because as I understand you, you're really saying that under certain circumstances, the DMA is constitutionally compliant and sections 23.8, 26.2, and 27 are not offensive, and you've given the example of a nationwide drought. But that its use under these circumstances is problematic.
Yes,
that's how I understood your response to Judge Keatley's question. Now, if
Yes.
that is indeed the case, then the issue of constitutionality or not can't be fact specific and say for these purposes the act passes muster, but for these it doesn't. And then if that is correct, it really brings us into the review relief, which is not before us today.
Yes. I latched on to and borrowed from Judge Kitely with regards to the national drought. My Lord must just remember, we don't know what regulations will be enforced in terms of such a national disaster and whether they will have the same effect.
You're not challenging those regulations. You challenging sections 23A, 26.2, and 27, and you're saying that under certain circumstances, those sections would not be offensive. It's
because
the manner in which the act has been used in this particular disaster that your client has a difficulty with.
Well, my Lord, and there's no oversight. Yes, it doesn't. There's no protection in the act whatsoever for founding value. Whilst we get it where there's business as usual, and we get it in the most extreme situation of a state of emergency, but not in a national state of disaster in terms of a DMA. There can't be.
But then it's not the act itself that is unconstitutional. This is where my brother Judge Collipin is going. It's the use of it.
It
can't
is
be.
The act. I beg your pardon. Excuse me, Judge. I think I
No,
interrupted.
carry on, please.
But the act is unconstitutional because, Judge, where there's a national disaster such as this, there's no guarantee, there's no constitutional safeguard in place. The act doesn't cater for it at all. And it should.
But then it's only unconstitutional in certain circumstances, not in others.
Under certain conditions. Yeah.
I'm sorry, Judge.
Okay. Respond to that. It's a. I mean, we taking this point to some detail because it's at the heart of, at least conceptually, how we understand the relief. And now I've read it and I've heard you saying that under certain circumstances, 23A, 26.2, and 27 would be fine, because those circumstances would not warrant the intensity of the kind of oversight that this disaster requires. And therefore, in my view, that answer must lead to the conclusion that the challenge is really not going to the heart of the legislation, but the manner in which the legislation is invoked. And maybe the high watermark of that argument would be that the government should not have declared a disaster, but an emergency, for example.
No, well, I don't think. Let me approach it differently. When this act was enacted, it was meant to cater for national disasters of any sort,
like the one we have now.
Like the one we have now, except the one we have now is managed in terms of this act, and there is no protection for the founding value that I've started with. The act
Mr. Stellenberg, there is protection. You are a living example of that protection. It might not be Parliament, but you're coming to court to protect basic rights and freedoms. It's just a different form of protection.
Well, but it's retrospective. It's not proactive. The people aren't governing at this stage, my lady. Not at all.
It's a very wide and sweeping statement, but I won't take you up on that.
No, let me underground it with what we know, what the papers show. The state of disaster, as well as the 27.2 regulations of 18 March, was not preceded by any meeting whatsoever of the National Assembly, any debate in House. The consultation process that the court has been referred to say that there is oversight in light of Parliament's constitutional obligation to do so, is consultations that have been arranged on short notice with the different stakeholders. It's not a debate in the House. There's no agenda. and no briefing beforehand. So it's not. It doesn't comply with what the business of the National Assembly would be. The court was referred to the portfolio chair of COGTA's portfolio committee's reaction, and the discontent of that whole committee with regards to the fact that they were not consulted before alert level 3's decision was made. So there's really no oversight. Yes, can the applicant come to court or any other person to ask protection from the court? Yes, but we have various obstacles that we must cross. To name two in this matter now, for example, is the urgency matter. Whilst in terms of the act that would cater for a state of emergency, the House would have had all the legislation and would have had the power to immediately veto any legislation or make recommendations with regards to it. So really what we have here is a well, basically a reaction every time. The decisions, the main decisions, hasn't even been taken by the executive according to the statements. It's been taken by the interministerial committee that has been established. But be that as it may, the fact of the matter still is that the National Assembly doesn't have a say in this national state of disaster. And it is by virtue of the fact that the DMA doesn't cater for that. It doesn't provide for that. So that is the short answer to that. And that is what the evidence shows us, my lady, with regards to that. Interesting enough, the third and fourth respondents indicated that had this matter been raised at any stage or tabled at any stage, then they would have had an investigation done into maybe having an amendment brought about to the relevant act, or taken other remedial action. But as the applicant explained in its further affidavit in response to that, there's never been any meeting where any of these matters were tabled for discussion, which goes back to the heart of our objection to the DMA as presently used to manage this situation. And obviously, that affidavit was supposed to 11 June. I would have expected, my lady, with respect, the government, first and second respondents becoming aware of the fact that the people were not happy, were not satisfied with the way in which the country is governed, to have approached the court by themselves to ask that the constitutionality of the provisions of the DMA be considered. But be that as it may, that does not happen. So yes, the Prayer 2 is couched in the alternative, but we respectfully submit that the act has been written to deal with national disasters. This is a national disaster according to the decision of a second respondent. And it lacks, it's got a lacuna. It does not sufficiently provide for parliamentary oversight, so it does not or effectively provide for protection of the foundational values enshrined in our constitution. And if that is so, my lord, then the sections authorizing the declaration and the conduct of a state of disaster falls foul of the constitution.
Mr. Snellenberg, can I just raise this with you?
Yes.
As I understand your relief, and as I understand what you identify as the gaps, as it were, in the oversight mechanisms that don't exist in the DMA,
Yes.
you really take that directly from those that apply in respect of a state of emergency, correct? They mirror that logic.
Yeah, yes.
So in a sense, it wouldn't be unfair to suggest that you're really saying that the same mechanisms that apply in a state of emergency must apply in a state of disaster. Now, I have a difficulty with that, because what you then do is then you seek to equate that. And therefore, by implication, say, if this applies in an emergency, it should apply in a disaster. But the jurisdictional facts that must be in place before an emergency can be declared is considerably different than in respect of a disaster. It's much higher. It's where the life of the nation is threatened. I mean, COVID, unfortunately, going to kill many South Africans, but it's unlikely that the life of the nation is threatened. And therefore, if there are heightened measures of accountability in respect of the state of emergency, it may be justified by having regard to the threat facing the nation. And therefore, by implication, it doesn't justify those same heightened measures in respect of a lower risk, which would be represented by disaster. And conceptually, isn't that, I found that in a sense at the engine of your argument, and I had a difficulty in that you seek to use the one to mimic, as it were, what should happen in the other.
Yes. Well, all those precautionary measures need not apply. The heart of the complaint, I've just tried to lucidly set out, and that is there is no parliamentary oversight, and in this state of disaster calls for it with respect.
But again, Mr. Stellenberg, that it again gets to the use of it in this case, in the case of COVID, as opposed to the act itself. And if I look at, and I'm not trying to harp on something, it's really important that we understand your relief and,
yes,
and your arguments in favor of it. If I look at relief in your primary relief in prayer 2, is declaring that the DMA is inconsistent insofar as it doesn't provide for the Section 37 safety, protections. Thank you. And yet your entire argument is premised on how it's used in certain circumstances. So if I understand correctly, that means you are no longer persisting with the relief in prayer 2, because your real complaint is how it's used in this situation. You know, you've just said the entire gamut doesn't have to be included, and it's how it's used to manage this crisis, whereas prayer 2 is to declare the whole thing unconstitutional because it doesn't include the protections under Section 37, which hasn't been the thrust of your argument as I understand it at all.
Well, my lady, 2.2, I don't think falls foul on what my lady has
Yes,
possible.
but that's your alternative. That's your alternative.
Yes, but still,
Isn't it?
I'm sorry, I understood that you said
that's your alternative. Your primary relief is that the act in toto is invalid because is unconstitutional. Are you persisting with that is really what I just want to determine.
Well, it's as far as we say that those provisions do not provide for oversight protection. But it is fact bound. I mean, what brought us here, my lady, is COVID-19. I mean that.
Okay, I think please proceed with your submissions, Advocate Snellenberg.
Thank you, my lord. The indemnification that we've referred to, the respondents say it's not necessary because in terms of the DMA, no rights are limited. We join issue with that submission for a simple sake that if we look at Section 61 of the DMA, we have a very wide indemnification, which says that basically anything done in any power or person exercising a power or performing a duty in terms of the Act is not liable for anything done in good faith in terms of or in furthering the objects of the Act. This is mirrored in terms of Level 5 regulations, Regulation E11, provided that no person is entitled to compensation for any loss or damage arising out of any bona fide action or omission by an enforcement officer under the regulations. So it is not correct that the DMA does not limit those rights. It has a pertinent indemnification in it. And because of the matter of how this state of disaster is managed, it needs no debate. I mean, every announcement, every public address, the populace is informed that you are suffering grave consequences, and we know that part of the population has approached the court to restate some of the basic human rights that the police and the defence force must observe. So those indemnifications, with respect, ties in with the fact that there's no National Assembly oversight, parliamentary oversight, and that's part of the complaint. The Act does not provide sufficient oversight, parliamentary oversight, and the present state of disaster has brought the jurisdictional elements into play for the court to see that this is a lacuna and this is a problem. My lords and my lady, we have. I don't think there's any dispute about the fact that the lockdown, the state of disaster has resulted in limitation of rights and suspension of certain rights.
Mr. Snellenberg, you use limitation and suspension interchangeably, but they are different, not so?
They're not different.
Yes. A limitation of a right is premised on the fact that the right still exists. The right is not suspended, yes. And therefore that limitation can be challenged at any time, and the state has the obligation to show it's reasonable and justifiable. I'm not aware that any rights have been suspended. You make the example of the right to trade, but that is not a suspension of the right. It's a limitation of the right which can be challenged at any time, and there's a threshold that the state must prove to justify. So would you agree that there's a difference between the two, and that we're not dealing here with the suspension of rights, but the ordinary limitation of rights that would happen even outside of a disaster?
If the response is short and to the point, my lord, the suspension is also a temporary limitation, but it doesn't work the other way around. We've referred in the edge to the dictionary meanings of the two words. So,
yes, but in law, they've taken on different meanings. Certainly, in the context of our constitution, not so.
Yes. We've made our submissions with that regard, my lord. I mean, the reference we used, the example we used, just illustrates that. I mean, there are certain businesses that are still they're prohibited from operating. They've been prohibited since the start of the lockdown, 15 March. They're prohibited. It's a criminal offence for them to conduct business. So we've used that as an example. But yes, unfortunately, limitation and suspension is also used interchangeably by the respondents, and it can probably be used in the wrong context.
Okay, thank you.
I don't opine that it's necessary. I mean, the drastic limitation, if you like, of almost every human right, I think is it's not contentious by this law.
Okay, but you equally accept that every such limitation, irrespective of how wide-ranging it is, can be the subject of judicial oversight.
Yes,
and indeed parliamentary oversight.
Yes, what we advocate in judges that if there are proper parliamentary oversight in terms of a DMA, then we wouldn't have a situation where we are reacting the whole time. Once somebody's human rights have been infringed, and it says that the limitation is unreasonable, he has to approach courts. During this state of disaster, which is not which is not always easy, because we know that the state of disaster also limited or curtailed the access to court. Whilst if the Act provides for sufficient oversight with regards to the regulations of promulgation and so forth, then we would be proactive, not reactive all the time. And because what we have here is a reaction every time. Judge, we've dealt with the limitation and the fact that there hasn't actually been any serious attempt to justify limitation of rights. Now, if that falls as part of a review, then we have a situation with the record, obviously, and the reasons that are lacking. But we have, for sake of completeness, referred the court to what we consider to be a very apt explanation in the Oaks judgment in Canada, where the court succinctly set out how the limitation test is to be applied. As far as evidence goes at this stage, there are virtually none with regards to that will enable us to do such an exercise. So that as far as the onus is, of course, on the entity that limits a right to show that the limitation is justified in terms of, in our Constitution, Section 36, limitation of rights are the exception to the rule, because we are working with protected rights. Maybe just a submission with regards to the affidavit that was appended to as an expert or as expert advice or expert evidence. And I see that the first and second respondent takes issue with the applicants joining issue with the admissibility. But it is the rules of engagement says that evidence was tendered apparently in another matter. And the deponent has not testified in these proceedings to say, well, what I say there is correct, and that renders it inadmissible. But even if the court wants to take cognizance of it, if it is relevant for purposes of adjudication of this matter, we respectfully request the court to just peruse that affidavit. It's right that when the court considers expert evidence, that the expert's conclusion must be based on facts, and the court must see how the expert arrives at a conclusion, and that is not the tenor of with respect of that affidavit. There are conclusions without any primary factual basis in that affidavit, and therefore the applicant joined issue with the presentation and the reliance on that. May I just take an instruction, my lords and my lady? I am quite finished, close to concluding my address. Thank you, my lords and my ladies. Sorry for that delay. I'm just, and I think I might have not made the submission clearly. If there is a suspension of rights, of course, the respondents agree that the DMA does not provide for that. That is the respondents' version as well. So if there is any mention of suspension of rights, obviously the DMA, the court can then accept on all the parties agreed that the DMA does not provide for that. My lords and my lady, this is the gist, this is the essence of the submissions with regards to what we submit is before you at this stage. Prayer to I hope I don't know how long my took, but I accept that JP would have stopped me if I transgressed the time.
Oh, you did very well with that.
Mm.
You've been very economical. You must practice a lot in this court, you know.
You mean in the Zoom court, JP?
No, in our division.
So, Advocate Snellback, thank you very much. I do understand that you can't say anything about the other relief you seek, because I think what came to the fore in what your client was challenging was also the declaration itself, right? So I understood you earlier to be saying you're persisting with 2 and 3, but the declaration falls in 3, but I suppose it is affected by the lack of a record. Am I understanding you correctly? That's why you're not saying anything.
My lord, the phase 3 is simply the referral of a finding in terms of prayer 2 to the Constitutional Court. The suspension of such a finding and referral in terms of the Constitution.
Yes. Oh, yes. Sorry. That's 4. Yes. Sorry. That's my misunderstanding. Sorry. Okay. Thank you very much for that. Advocate Trengove.
Thank you, Lords, my lady. It is not clear to me what our learned friend's case is on what the issues are before the court. Because if I may refer to the notice of motion, that is in volume 6, and more particularly from page 2. Then they really, apart from urgency and remedy, urgency and cost and so on, there are 3 substantive attacks. Prayers 2 and 3 are an attack on the Act itself. And it's common cause that those prayers are before the court today. Prayers 4 and 5 are both an attack on the declaration of the state of disaster. And I'll come back to them because they are controversial. And then prayers 6 is an attack on the extension of the lockdown. It's common cause that it is not before the court. What is not common cause is the status of prayers 4 and 5, because what the applicant sought to do was to insist that prayer 4 be heard today, but prayer 5 be postponed. And we take issue with that position because prayer 4 is a declaration, is a prayer for a declaratory order that the declaration of the state of disaster is unlawful. Prayer 5 is a review of the same declaration. That says the applicants are 2 different causes of action, and therefore it insists that the one be heard today and the other one be postponed until after they've obtained the record. But we object to that attempt because we submit that prayers 4 and 5 are both the self-same attacks on the self-same target, just using different words. To say, I ask for an order declaring that the declaration of the state of disaster is unlawful, is the same as saying, I ask for a review of the declaration of the state of disaster.
Advocate Trengove, I think that is the prayer 4 part. The first part is what I actually wanted to clarify with Advocate Snellenberg, because that's the declaration of the national state of disaster. And he has made no submissions in that regard. I wanted to clarify what was the reason, but he may explain himself now, or maybe he'll do so in reply. But perhaps you may want to continue, because that's what was troubling me, to say That's the declaratory relief part of the declaration of the state of disaster, right?
Well,
and he said nothing about it.
I'm not sure that he didn't say anything about it because it was unclear. His attack on the expert evidence filed in support of the declaration of the state of disaster, that clearly is a prayer 4 attack, part of prayer 4 and prayer 5 attack on the declaration. That's got nothing to do with the act. Yeah. And then there was this other confusion throughout his submissions when he sought to advance his case by arguing about the manner in which the current state of disaster has been declared and managed. That can't, as Justice Keatley pointed out, that is irrelevant to the validity of the act. That goes purely to its implementation in this case. So the line has been blurred all the time. And what we object to is the applicant's attempt to have 2 bites at the cherry, to have a prayer 4 review of the validity of the declaration. And if they lose, to come back on another day for a further review of the same declaration, because we submit that to say that there's a distinction between a prayer for a declarator that the declaration is invalid and a prayer for a review of the declaration is the same thing. It's as a matter of law, there's no distinction between the two. And may I refer in this regard to 2 cases that we have not been included in our heads, but they have been uploaded onto case lines. The first is the Constitutional Court judgment in Benguanyama Minerals. It's Benguanyama Minerals v. Ganora Resources, 2011, Volume 4, SA 113, Constitutional Court. It is in the case lines bundle in bundle 53. It is item 30, page 1335. Now, in that judgment, at paragraph 84, Justice Vroneman, speaking for a unanimous court, said the following. He said it would be conducive to clarity when making the choice of a just and equitable remedy in terms of PILA, to emphasize the fundamental constitutional importance of the principle of legality, which requires invalid administrative action to be declared unlawful. In other words, in a standard review, His Lordship says, if you conclude that the administrative action is unlawful, then the first order of business is a declaration of invalidity. The same court, same judge made the same point in the Allpay case. This is Allpay 1. That's Allpay Consolidated Investment. The CEO of SASSA, the reference is 2014, Volume 1, 604, Constitutional Court, paragraph 25, where Justice Vroneman again said for a unanimous court, once a ground of review under PIA has been established, there is no room for shying away from it. Section 172(1)(a) of the Constitution requires the decision to be declared unlawful. So the distinction that the applicants seek to make between a declaration of invalidity on the one hand and a review on the other is a false distinction. And their attempt to have the one heard today and the other one stand over until a later date is, with respect, an unjustified attempt to have 2 bites at the cherry. We submit with respect that what they brought before the court today includes prayers 4 and 5, and we would urge the court to adjudicate them and to dismiss them because they haven't made out a cause of action and they shouldn't be allowed to have another bite at that cherry. May I then turn to another topic, just a preliminary topic before I get to
Sorry, Mr. Twendo, can I just clarify this? Are you saying that the basis for us dealing with and dismissing the relief sought in 4 and 5 is that it before us and the applicants had made the election to proceed with the matter, and that the absence of a record cannot stand as an insurmountable obstacle to us dealing with it. That's the choice the applicants made, and that's the way in which we must dispose of it. Is that what you're saying?
Yes, absolutely. Remember, the question whether the applicant presses for the record or not is a matter of choice. And in this case, the government said to the applicant, you've given us 4 days to produce a record. We would normally have 3 weeks under the rule. You can't, we simply can't produce that record in 4 days. Now you choose. You can either wait for the record and have a hearing in due course, or you can have the
I think he's frozen.
Yeah.
There we go. You're back, Mr. Tringo.
Oh, I'm sorry about
You
that.
froze.
I'm sorry about that. So the government said to the applicant, it's up to you. You can choose. You can have an urgent hearing without the record or a hearing in due course with the record. You choose. What it does, it says, I'll go ahead with prayer 4, but not with prayer 5. In other words, it's trying to have it both ways. And we submit that either choice would have been a legitimate one. But to try and split them and have it both ways is not justified.
Okay.
May I go on to another issue which permeates the rest of the debate, and that is the requirements for the pleading of a constitutional attack. Because I'm not sure that our learned friend adheres to the basis on which the constitutional attacks have been pleaded. And it does seem to me at times to have left behind the pleaded causes of action altogether and to argue other matters. But the Constitutional Court has repeatedly made it plain that constitutional attacks have to be pleaded with a great deal of specificity, and that parties are not allowed to argue constitutional attacks on grounds other than those that have been specifically pleaded. And perhaps the most convenient reference that I can give you is the most recent one of the Constitutional Court in the case of PSA, that's the Public Servants Association, the Department of Health 2018, Volume 2, SA 365, in paragraph 50, and the case is also in the case lines in volume 53. It is item 6 at page 35. The actual paragraph, relevant paragraph, is at page 41. So that it is important to adjudicate this case on the basis of the causes of action, the attacks made, and the causes of action raised in the founding papers, and not on some other basis. Can I turn then to the issue of urgency? The only matters before the court today are the first, and we submit the second attack. That's the attack on the Act itself, and secondly, the attack on the declaration of the state of disaster. The Act has been in force forever, but the declaration was declared in the middle of March.
JP, I'm sorry, I think Judge Colopin's frozen now.
Yeah, it appears he's frozen, yeah. Oh, he's
there
back.
we go, he's back.
Okay, sorry about that, Advocate Tringo.
I thought it was my submission that stunned him. The real delay here, remember, before the court today is the Act and the declaration of the state of disaster. The Act has always been there. The declaration of the state of disaster was mid-March. The application was launched end of May. That's 2.5 months later. 2.5 months, which is never really explained, except that we changed our minds about this, being nice about it, and we decided to fight the government. But urgency is not judged in the abstract. One looks at the circumstances on the one hand, and then the degree of urgency with which the application is brought on the other. And what these applicants did, after having been passive for 2.5 months, is they came with an application with the most absurd urgency. They imposed a series of deadlines, which were absolutely absurd. My clients would have had 4 days to produce a record and 2 days to produce an answering affidavit. Now, there is just no balance between those two. My client would normally have 15 days to produce the record and 30 days, that's 6 weeks, to produce an answer. For them to force us into doing the same work within 4 days for the record and 2 days for the answer was an abuse and simply not justified. And we submit with respect that this application should be dismissed for lack of urgency. Can I turn then to the act, the attack on the Act? That's the prayers 2 and 3 attack. And I come back to the submission we made that constitutional attacks have to be specifically and clearly and expressly pleaded. So what I'm going to address is the basis on which this attack has been pleaded, as opposed to the basis on which it has now been argued. And as was made clear earlier, the pleading of this attack, it was absolutely clear, both from the notice of motion and from the founding affidavit. The notice of motion, if I can go back to volume 6, page 2, if you look at, I'm not going to read prayers 2 and 3, but what they make plain is that the foundation of the attack on the Act is that it does not incorporate the same safeguards Section 37 requires of a state of emergency. That was the beginning and end of that attack, that it does not comply with the various safeguards built into Section 37 of the Constitution. And that's not only the prayers that made it clear, but the founding affidavit where this attack was pleaded also made it plain that that was the foundation for the attack on the Act, is that it lacked the safeguards of Section 37. The founding affidavit, that's volume 6, page 82, paragraphs 142 to 158. So the only legitimate cause of action before you is whether it can be said that the Disaster Management Act, or those three sections of it, are invalid because they allow for the declaration of a state of disaster without building in the safeguards required by Section 37. But the fallacy with that cause of action is with respect threefold, and if I may, well, manyfold, but three that we wish to emphasize. And that is this, that the applicant fails to appreciate that there is a difference between a state of emergency on the one hand and a state of disaster on the other, or fails to, they of course appreciate that they have different names, but they fail to appreciate the fundamental difference between the two. And the difference is, in the first place, as His Lordship Mr. Justice Colopin mentioned, the threshold for a state of emergency is much, much higher than for a state of disaster. You cannot imagine a more stringent threshold test than the one set by Section 37(1), namely that the life of the nation must be threatened not by anything, but by war, invasion, general insurrection, disorder, natural disaster, or other public emergency. So the life of the nation must be threatened. But even that on its own is not enough. It must also be, a declaration of a state of emergency must also be necessary to restore peace and order. So it postulates not only that the life of the nation is threatened, but that there is no peace and order, and that the state of emergency is necessary to restore peace and order. So that threshold is far, far higher than the eventualities for which the Disaster Act caters. Why, and then to get to the second point, why that high threshold? The high threshold is set precisely because the section allows for the wholesale suspension of all but a handful of fundamental rights. In other words, it allows for the suspension of the Bill of Rights. And His Lordship, Mr. Justice Colopin, made the point that we're not talking about limitation of rights justifiable under Section 36. We're talking about the temporary abolition of those rights, where government is allowed to act regardless of those rights and without regard to them. And it doesn't turn on our language of suspension or the language of limitation, because the Section 37 doesn't even speak of suspension. It is more explicit than that. Section 37(4) says, any consequence of a declaration of a state of emergency may derogate from the Bill of Rights only to the extent that, and then there are limitations imposed on it. But the heart of a state of emergency is that it allows the government temporarily to lift, to suspend, to knock out the Bill of Rights. And that is a fundamental incursion into those founding values that my learned friend described this morning. And it's a fundamental departure from the constitutional state that we are. It's a fundamental departure from all of those founding values. And it is a fundamental departure precisely because it is recognized that there comes a time in the life of a nation where it might be necessary even to suspend the most important parts of the Constitution. And that is why this section allows for that suspension, but only in the most stringent circumstances, and then builds in some safeguards, which it says in effect that even when you are allowed to suspend the Bill of Rights, there are certain basic rules that you have to adhere to, and those are then the basic rules of 37. But they are safeguards imposed precisely because the rest of the Bill of Rights is derogated from during the state of emergency. So there's just no comparison between the two. Under the state of disaster, the most fundamental difference is that the Bill of Rights stands tall and is valid and is binding. And it is open to any citizen, like these applicants, to come to court to challenge any exercise of the powers under the Disaster Act for its infringement of any of the rights in the Bill of Rights. That is, after all, the basis of the attack on the Declaration, prayers 4 and 5, and the basis of the attack on the extension, that's prayers 6. So this case is a living testament to the difference between a disaster on the one hand and a state of emergency on the other, because under a state of emergency, the Bill of Rights may be derogated from, not quite in whole, but almost in whole. So under the state of disaster, the judicial oversight of the entire declaration and implementation of the state of disaster and the management of the state of disaster is subject to the ordinary judicial control, as all other government action, legislative and executive action, always are. And therefore, there is no justification for equating it with Section 37. But let me add that, and that is that even to the extent that there are a comparison to be made between the two, my learned friend keeps on saying that what is lacking is parliamentary oversight of the state of disaster. But even Section 37 does not require parliamentary oversight of a state of emergency. The only safeguard it requires that you won't find in the Disaster Act is that the extension of the state of emergency after the initial 15-day state of emergency, every extension has to be approved by the National Assembly. But that is the only role of the National Assembly. In other words, the Constitution recognizes that where you allow government to suspend the Constitution or the Bill of Rights, then it is necessary that the National Assembly authorize the extensions of that suspension from time to time. But the management of the state of emergency, the laws made under the state of emergency, none of that is supervised by Parliament, as our learned friends would have it. So
Mr. Twendo, can I ask this, please? And working on the basis that qualitatively one is dealing with two different scenarios in a state of emergency and in a state of disaster, and leaving aside whether the kind of mimicking is permissible, but looking at the objections raised on their own, if you follow me. So there's no parliamentary oversight, not because it's in the state of emergency, but because as a matter of principle, it's important. Let's use that as. Now, given that it's also implicit that in a state of disaster, there would be incursions of rights and limitations, and courts can pronounce on that, but as it were after the fact. The absence of a parliamentary oversight, in particular with regard to the extension of a disaster, should that in your view trigger any concerns with regard to as it were, how the balance between executive power and legislative power is finally calibrated? And could that ground a basis for the unconstitutionality attack?
Let me say, there is certainly a debate to be had about it, and that I accept. But it's in the first place, that is not the debate they have raised. They have simply derived their argument not from the ground up, but from their comparison with the state of emergency. But there are two further answers to it, and that's this: that what you have under a state of disaster, as I've said, you have judicial control under the Bill of Rights, which is a fundamental difference, and it destroys all comparison between state of emergency on the one hand and state of disaster on the other. But secondly, and more to the point to your question, my lord, the suggestion that there is no parliamentary oversight is simply not correct, because there is certainly the Constitution certainly requires the Parliament to hold the executive to account. And can I give you 3 provisions of the Constitution that requires it to do so? The first is Section 42(3), which provides that the National Assembly is elected to represent the people and to ensure government by the people under the Constitution. It does this by choosing the president, by providing a national forum for public consideration of issues, by passing legislation, and by scrutinizing and overseeing executive action. That's the first one. The second is section 55(2)(b). Well, maybe I should read the whole of 55(2). It says the National Assembly must provide for mechanisms, A, to ensure that all executive organs of state in the national sphere of government are accountable to it, and B, and this is the important one, to maintain oversight of the exercise of national executive authority, including the implementation of legislation and any organs of state. So, and you'll remember the Constitutional Court judgment in EFF, the Nkandla case, which turned very centrally on that provision. And then there is lastly section 92(2), which provides that members of the cabinet are accountable collectively and individually to Parliament for the exercise of their powers and the performance of their functions. So our learned friends are wrong when they say there is no parliamentary oversight. And you will have seen that Parliament has certainly been very active in keeping oversight over the management of the state of disaster. If the complaint is that Parliament hasn't done so properly or sufficiently or stringently enough or whatever, then that is a different attack that can be brought under those constitutional provisions. But simply to argue that there is no parliamentary oversight is not correct. The Constitution requires the National Assembly to keep parliamentary oversight. And in a state of disaster, which is a state of high executive control and management of the country, that duty would be a heightened duty, and there would be a case to be made to call Parliament to account for the way in which they perform that function.
But just on that, Mr. Trengrove, and I know we get pulled back to the comparisons because in a sense that's the foundation on which the applicant launched the case. Yeah. It might be unfair to you to, as it were, seek to move away from the foundation and build a different case for the applicant, and I don't wish to do that. But there are differences, and perhaps the differences can be explained by the threshold point you made at the start, because in terms of the State of Emergency Act, for example, the two significant differences is that any extension must be approved by Parliament, and then secondly, any regulations that are made by the President or any other member of Cabinet in terms of the State of Emergency Act can be revoked by Parliament. Those don't apply here, but the threshold argument would say, well, why should they apply here?
No, indeed. But let me just make the point. The first of those requirements is a constitutional requirement that the National Assembly must approve every extension of the state of emergency. My submission is that is precisely because it is those extensions that suspend the Bill of Rights, and therefore that's a very peculiar function. But on the ongoing supervision, for instance, the power to veto regulations, it is true that that power is built into the State of Emergency Act, but it is not a constitutional requirement. It is simply Parliament has chosen to build that protection into the State of Emergency Act, presumably because they appreciated that under a state of emergency, the scope for executive lawmaking is unrestrained because the Bill of Rights doesn't apply. But whatever the just explanation for it is an add-on beyond the constitutional requirements of Section 37. And if you ask yourself in this case what the constitutional requirements are, then the constitutional requirements are those of Section 37. And it does not require, even under a state of emergency, even where the Bill of Rights has been suspended, it does not vest the National Assembly with powers to veto regulations or in any other way interfere with the executive management of the state of emergency. So we would submit that not only does the analogy not support the attack, but the analogy contradicts the attack because it doesn't even require in a state of emergency the kind of oversight that our learned friends argue for here. So that we would submit then that the attack on the Act is ill-founded, because the beginning and end of that attack was the false comparison with the state of emergency, and therefore the suggestion that the Disaster Act has to comply with the requirements of Section 37. If I may turn then to the prayers 4 and 5 attack, that's the attack on the declaration of the state of emergency in this case.
Advocate Trengove, I just need to check, how long do you think you'll be in dealing with those?
I suspect I'll be 10 minutes at most, Judge President. 10
minutes, okay, no, we can survive 10 minutes. We've missed our constitutional tea break, but anyway, you can.
I'm entirely in your hands. You must just tell me whether you prefer to do it now or after I've done.
Please continue. Please continue.
The attack on the prayers 4 and 5 attack on the declaration of the state of emergency suffer the same flaws as the attack on the Act, because the foundation of the attack is again that the declaration is subject to the strictures, or the same strictures as those imposed by Section 37. If you were to, I won't ask you to go there, but if you look at prayers 4 and 5, you'll see that the only grounds of the attack on the declaration that are specified in prayers 4 and 5 are Section 37 grounds. In other words, that the declaration falls foul of the requirements of Section 37. And that is, the attack is made in the founding affidavit, that's in volume 6, page 88, in paragraphs 159 to 171. And you will see that in those paragraphs, there are 2 grounds of attack that are raised. The one is, again, the declaration does not satisfy the requirements of Section 37. Now, I won't repeat my submissions on it, but it is as inappropriate here as it is in the attack on the Act itself. The only other attack raised is an attack suggesting that the international health regulations should have been invoked rather than a state of disaster. That attack is made in paragraphs 165 to 168. But the respondents make it clear that the purpose of the international health regulations is to ensure international cooperation to combat the spread of a pandemic internationally. It has nothing to do with the internal management of a pandemic once there is a breakdown of a pandemic. So that the international health regulations are entirely inappropriate and inapposite. And the suggestion that they should have been invoked instead is just unfounded. And in fact, even if we're mistaken, even if there was that remedy available to be invoked, there's no reason, because the state of disaster requirements were so absolutely and clearly met in this case. I said that there were 2 grounds. There's a third ground in paragraph 171 of their founding affidavit, where they say that they raise a hearsay statement that somebody was not consulted before the declaration was made. But it's a hearsay statement, and there's no constitutional requirement or statutory requirement for the consultation of all concerned before such a declaration is raised. So in conclusion, the attack on the declaration stands on 3 legs. The first is the false comparison to Section 37 and a state of emergency. The second is the international health regulations, which are entirely inapposite. And then the third is this hearsay statement that somebody was not consulted. And we submit, therefore, that that attack was also ill-founded. The respondents present and the minister ask that prayers 1 to 5 of the applicant be dismissed. I want to say with costs, but I would imagine that BioWatch would apply, and therefore that it wouldn't be appropriate to make an order for costs.
So,
Thank you.
Advocate Ndlovu, whatever happens to the attack or challenge on the declaration of the national disaster is solely dependent on what happens to the attack on the Act.
We submit yes, because the same flaw infects both, and it's a fatal flaw, because both attacks are founded on the premise that the safeguards of Section 37 are applicable.
Yes.
But there are additional grounds not so. So it's capable of being adjudicated on its own as well. Sort of the IHR ground is a self-standing ground, is it not?
That's true. No, that's true. And the failure to consult some expert is also notionally a separate ground.
And if we were to declare Section 27 to be unconstitutional as pleaded, it survives. But if not, then it doesn't.
If you uphold the attack on the Act, of course,
Yes.
then everything done under the Act would fall with it.
Yes.
In other words, you wouldn't even reach prayers 4 and 5 if you uphold prayers 2 and 3. Then we would ask you to, as is commonplace, that you suspend the declaration of invalidity to give Parliament an opportunity to fix it, because you clearly don't want to just overturn the apple cart in the middle of a disaster.
Yes. Okay. Thank you. Thank you very much. Advocate Snellenberg, you have the right to respond.
Yes.
How long will you be?
Well, I'm not sure. It depends probably on the questions as well.
Judges Colopin and Kidney, I've invaded your tea break. Should we continue? I don't mind continuing.
Judge, we're in your hands. If you want a short adjournment, we won't detain you.
I'm happy to continue.
Continue, okay.
I'm happy as well to continue.
Okay. Thank you very much. Please continue, Advocate Snellenberg.
Judge, we've referred you to the supplementary heads. It's a bit opportunistic for the respondent to ask you to dismiss the entire application, including the review prayers, where it has not made the record available. We have explained the challenge from an applicant's point of view. Remember, the applicant doesn't know what the record consists of. But here's a problem with dismissing the application, including the review prayers. If a record is made available, then the applicant has the right, pursuant to the reasons that has been given and the documents contained in the record, to amend its relief and to file a supplementary affidavit. I think Judge Colopin referred to that earlier. So what the second and first respondent is arguing is that right must be taken away whilst the applicant accepts that there might be a challenge to produce it. But until now, neither the applicants nor the court knows what the respondent, first and second respondent, suggest is a fair opportunity. Because remember, in terms of Rule 53, they would have had 3 weeks, but that's not what they said in the correspondence. They said it will take weeks to prepare it. So there's a bit of a disconnect. And to then come to court, not supply that record, not comply with the constitutional obligations, as we've pointed out in our supplementary heads, which is part his state's obligation, we respectfully submit it's a bit opportunistic. We have argued.
Mr. Snellenberg, on that point, do you accept that it is open to an applicant to elect to proceed without a record? You don't dispute that principle, as
No,
if I understand you correctly. You don't want to proceed with 4 and 5 without a record. Is that correct?
I understand the cases that we referred you to, my lady, in the supplementary. It says the court should not review without a record.
Mm. And Mr. Snellenberg, in a case like this, where according to the respondent, and it accords with my reading of the papers, the large part or the sort of keystone of your 4 and 5 relief goes back to the safeguards or the absence of safeguards comparative to a state of emergency. Is that correct?
Yes, but which obviously after perusal of a record, my lady, that might change, the relief might change. But we don't have a record and it hasn't been given to us. And there's no indication of how long it will take to make it available.
But as it stands now,
yes,
you base it on the same, it goes hand in hand with prayers 1 and 2, doesn't it really?
4 and 5, my lady.
Yes.
The review of the decisions, obviously that is subject to what the record will show, my lady. Well,
no, but the basis for the review is that it's unlawful. Yes. But
my lady,
well, if there are other grounds of review that pop up later, when the record appears, you're not prohibited from raising additional grounds. At the moment, your grounds are that it's tied to 1 and 2. Those are your grounds at the moment.
And the obviously the reference to the other legislation.
Yes, of course.
The jurisdictional.
And those don't need a record. What you are saying is that there might be additional grounds that pop up in a record.
Well, and we'll obviously the record will show on what basis the minister was satisfied to declare the state of disaster in terms of a DMA.
But is that part of your case in your founding affidavit?
We say that there were the jurisdictional requirements for a state of disaster in terms of a DMA was not satisfied. The respondents joined issue, and we have not had sight of a record. So that the record would inform that decision or not.
Okay.
The relief and prayer 5, with respect, my lady, is not simply based on the comparison with section 37. The applicants have made a case that is concerned that the foundational values have been neglected, for lack of a better word. The review relief, I said from the start, we accept that the court should not do it and would not do it without the record. And the only dispute that there was prior was actually whether section 4 constituted a review a relief or not. Because if it's a review, we don't have a record. And we argued prayers 2 and 3 because it's properly before the court with respect, as we indicated when we commenced. The applicants seek the dismissal of the entire application.
Mr. Snellenberg, can I ask this? To some extent, you've advanced the case on the papers in respect of the relief in terms of 4 and 5. But to a large extent, you say that you advance that relief with one hand behind your back because you don't have a record. Having elected to come to court, and is it not open to the court to adjudicate the relief in terms of 4 and 5 on what is before us. It's always open to the applicant to come again, raise judicata wouldn't stand in your way, because then you would be able to advance additional review grounds if, for example, a record throws up something beyond and above what is before us. So in a sense, it's not prejudice that is irreversible.
Just but Prayer 2.2, the alternative. The arguments are consonant with 2.2 that has been presented this morning to you. But we are constrained with regards to submission, with regards to review, because we have not received a record. And it was common cause between the parties that the record is needed and it's required. So yes, the applicant can come to court, but now the problem that the applicant had is it wants to vindicate its right. The first and second respondents say you're allowed to vindicate your right, but the record's not made available and there's no clarity of how long it would have taken. The applicants immediately conceded and said, but we are willing to extend the time frames for production of that record. Let's proceed to court of matters that can be properly adjudicated.
Mr. Snellenberg, did your heads of argument not cover Prayer 4?
I think it's Prayer 4.1 it covers. As far as not a review, but yes, there was reference to it.
Yes. So we can at least look at that. You might not have advanced oral argument, but you've advanced written heads. It's a bit late in the day now for you to say you're not proceeding with that, surely.
No, my lady, what we've said from the start is that in absence of a record, and as far as the part of Prayer 4 relief constitutes a review, then there should be a record. That's how we understand the Concord at SCA case law to say. And the respondent it was Prayer 4 at least partially was covered in the heads of argument. Without the record, it was stated, but it was. You're right. Just coincidentally, the International Health Regulations Act also provides for the National Assembly to make certain decisions before certain things are done, as we've referred to in our heads. The first and second respondents moved for an order that the entire application be dismissed on the grounds of urgency. That is not the usual order that is made if there is a lack of urgency. If a court finds it doesn't enroll the matter. But again, with respect, where it's common cause between the parties that some of the prayers would not serve before court to then argue that the whole application be dismissed, seems a bit opportunistic.
I think one of the people in this call is unmuted and we can hear whatever they are saying, wherever they are.
I think that's me.
Okay. Judicial misconduct. Mr. Snellenberg?
I'm sorry, I'm just checking my notes, so please, just a small indulgence.
Okay, no problem.
Lastly, we would just like to, as far as the submission was made that the applicants are wrong, there has been parliamentary oversight. The court will remember that Parliament was suspended on 18 March until further notice, and the first session thereafter was 10 April. So from 18 March until 10 April, we know, as part of this state of disaster, Parliament was suspended. Wasn't in session. The third and fourth respondents have produced information and evidence of what they conceive to be parliamentary oversight, and the court can look at that. It's not oversight. It's a consultation process which the applicant has dealt with, but there's no oversight. So those are the submissions in reply with respect.
Thank you very much. Any questions from Judge Kolapen, Judge Kitley?
None from me, thank you.
No questions. Okay. I would imagine Advocate Maineche has strict instructions to keep his mouth shut, so he'll remain that way.
Yes, indeed, my lord.
Okay. So we will not give you an opportunity to say anything. So thank you very much for the submissions and the very helpful submissions, in written submissions that we received earlier. We're going to reserve our judgment, and we won't be taking too long. And in light of the times we're in, when the judgment is ready, it will be emailed to the parties.
Thank you, Judge.
Thank you very much. So this is then the end of these proceedings. The court adjourns.